Thank you for joining us for this webinar on state and federal law developments. What will the legislators think of next? I'm Shannon Farmer. With me today is my colleague, Catherine Crawford from Ballard Spahr. We encourage you to submit questions as we go through the presentation and the amount that we need to cover. We're not going to be able to answer your questions directly during the presentations, but you can submit questions 2 ways, either through WebEx at the bottom right-hand corner of the screen, or you can email either Katie or I directly, and we'll get back to you with answers to your questions. Today is state and federal law developments. What will legislators think of next? Some of you may have been in a previous presentation that we did last May. You'll see, I think, when you look at this presentation today, for those of you who are on this in May, that some of the themes that we're seeing are similar to what we talked about last May. Sitting here a year ago, when President Obama took office, many observers, including us, expected there to be a flood of pro-employee legislation and regulation. And that was based both on the Democrats' control of the House and Senate at the time and the numerous initiatives that had been part of the campaigns of both President Obama and leaders of Congress. Things have been introduced and they're pending, but relatively little has in fact materialized. And I think a lot of observers believe that's in part because so much has been bogged down in the healthcare debate. So other legislative initiatives, particularly things that have been controversial, have taken a back seat. I think the changes in the national economy that have happened in the past year and the strain of the recession has also taken its toll as it's more difficult for legislatures on both the state and the federal level to tackle things that are pro-employee. And there's really a struggle, I think, that you see, and you see it in state legislatures, you see it in federal legislation, between wanting to pass measures that are pro-employee and protect employees, particularly in a difficult time, pressure from the unions to pass legislation that's being backed by the unions, but then also balancing that with the need to protect businesses in a fragile economy and not wanting to do things that in fact are going to put such burdens on business that it's going to cost jobs. And what we'll do today is talk about some of the highlights, some of the significant measures that are pending that have been passed on both the state and the federal level. Obviously, we're not going to talk about every bill that's pending in Congress, much less every bill that's pending or that it's been passed in state legislatures. When we talk about things that have been enacted, for the most part, we're talking about things that have been enacted in 2009. So if you're sitting there and you're looking as we go through and it says, wait a second, my state has passed a bill that does the same thing, why isn't it there? We're really focusing on what's happened in the past year and what's pending now. Another thing to keep in mind, particularly when we're talking about state legislative agendas, in many states, the legislative sessions begin in January. So we're fairly early in the session. So if we were to do this presentation 3 months from now, we'd probably see more states listed on some of these things, but we'd often see a lot of the same themes. And so what we're really trying to highlight for you are themes that we see where there are areas that you should be on the lookout for. If you have a question about your specific state, you can certainly email us or we can talk about where you can get more information on your specific state. This is not a catalog. If you don't see your state listed in a particular area, it does not mean that there isn't legislation pending or there isn't legislation that's been passed. This is not intended to be taking the place of doing the due diligence to know what's happening in your state, but really to give you an idea of what the big themes that we're seeing and where we think that there's going to be more. One of the most significant things that I think has happened for employers in the past year at the federal level, we haven't seen, as I said, a lot of legislation being passed. We have a lot of things that are pending, but employers have spent, I think, this year in a lot of ways coping with some of the significant changes that took place late in 2008 and early in 2009 in a number of areas. So we're going to talk briefly about these today, starting with the ADA Amendments Act. The ADA Amendments Act took effect January 1st, 2009, and the significance is that it dramatically expanded who is protected under the ADA in several ways. It gave a broad definition of substantially limited. You'll recall under the ADA, in order to be disabled, you must be substantially limited in one or more major life activities. So just an impairment is not enough. So that definition is significant. It expanded what major life activities could be considered as disabilities to really nearly any bodily function. It also provided coverage for episodic or dormant impairments. And this is significant because a number of areas where somebody has chronic condition that is not constantly disabling or substantially limiting, but it can be. And what the ADA amendments did was expanded that and said we're going to look at somebody in a condition when they're having the episode. And really in the statute itself is not any guidance on how frequent those episodes need to be, how many of them there has to have been. So let's take migraine headaches, for example. If somebody has a migraine during the period of the migraine, perhaps they are substantially limited in a major life activity. When they're having a migraine, they're not. Under the ADA previously, you would look at that and you'd say, they're not substantially limited in a major life activity. Now you look at them as they exist and what they can do and how their functions are impaired during one of those episodes. So that is a significant expansion. Another significant expansion is eliminating this idea of mitigating measures. So based on a couple of Supreme Court decisions, the law had been that you consider the person with mitigating measures in place. Medication is a good example. Somebody has high blood pressure, it's controlled by medication. When they take their medication, they're not substantially limited in a major life activity. Now, under the ADA Amendments Act, you look at it and say, if it were not controlled by medication, would they be substantially limited? Basically, under the ADA Amendments Act, you're looking at the individual in a worst-case scenario. Significant change is a much broader definition of what it means to be regarded as disabled. Under the ADA, it prohibits people who are actually substantially limited in a major life activity, people who have a history of impairment, or people who are regarded as disabled. Now, you can be regarded as disabled in two ways. One is you have an impairment that is not substantially limiting, but the employer believes it to be substantially limiting. The other is that you don't have an impairment, but the employer believes that you do. The law had been to the ADA Amendments Act that it was enough that the employer believed you to have the impairment. The employer had to believe that you had an impairment that was substantially limiting. Now, if the employer believes that you have the impairment, that's enough. So that's significant. It is going to be, I think, particularly significant in the area of mental illness and things like that. So if an employer believes somebody has a mental illness, even if they do not, even if the employer believed that they could function with that mental illness, they're now regarded as disabled. So they cannot be discriminated against on that basis, although you don't have to accommodate the person if they are not, in fact, substantially limited just because you regarded them as. And that also cleared up an area where there was some dispute among the federal courts. The one of these elements that I want to talk a little bit more about today is substantially limited. So on the question of what it means to be substantially limited in a major life activity, the ADA Amendments Act said that the EEOC's previous definition was too restrictive, but the ADA Amendments Act didn't offer another one. Before the ADA Amendments Act, the EEOC, in their regulations, defined substantially limited as unable to perform major life activity that the average person in the general population can perform, or significantly restricted in the situations in which the individual can perform that particular major life activity as compared to the average person in the general population can do it. The ADA Amendments Act said, no, that's too restrictive. In response, the EEOC has issued new proposed regulations, and these regulations delete the significant restricted language and provide that an impairment is a disability if it substantially limits the ability of an individual to perform major life activity as compared to most people in the general population. They also provide that substantially limits, including the application of that term to the major life activity of working, which is significant, is to be construed in favor of broad coverage of individuals to the maximum extent permitted by the terms of the ADA. So you shouldn't be looking very hard at this. In the EEOC's view, basically, if you have an impairment and you can show some limitation, a disability. You shouldn't be looking at scientific or medical evidence. Common sense is enough. And if an individual has an impairment that substantially limits a major life activity, then they don't also have to show that it interferes with their ability to perform tasks of daily living. So regulations that are pending, significantly expanded reach of coverage under the ADA in light of the Amendments Act, I think that more employers are going to be focusing not on whether the person is disabled, because frankly, in almost every case they're going to be, but instead it's going to shift to reasonable accommodation, interactive process, and that's really where the debate is going to be now. An area that employers have been coping with is changes to the FMLA. There was a regulatory overhaul of the FMLA in January of 2009. There were a number of procedural changes, new notice forms for the employees, new notice forms for the employer. There's now a two-step process. There's a new medical certification form, new forms for responding to the medical certification. They provided regulations for leave for military families for qualifying exigencies, and also leave to care for a family member who is injured as a result of military service. Significant changes, I think, most significant for most employers. One is employers can now disqualify employees from perfect attendance bonuses because of FMLA leave, and the other really is the procedural changes that have made it easier for employers to apply their general leave rules to FMLA leave, and have also expanded employee rights to get clarification of medical certifications. On the FMLA previously, if an employer had questions about a medical certification, they couldn't call up the doctor and get those questions answered. If they couldn't read something, didn't understand something, now what the employer could do previously was have a medical professional employed by the employer or under contract to the employer contact the doctor, but couldn't have the HR person do it, couldn't have somebody in-house do it. Now you can do it in-house. It just can't be the direct supervisor. So it's giving some additional flexibility to employers. It also, in the new regulations, provides some more specific steps in terms of notifying employees that there are deficiencies in the certification, giving them an opportunity to cure, and additional procedural rules. So if anybody out there has not looked at these new forms, I would advise that you take a look at the DOL website or contact counsel about how you need to revise your FMLA policy if you have not done so since these January of 2009 rules took effect. Another significant element that employers are dealing with is the Ledbetter Fair Pay Act, and Katie is going to talk about that.
Thanks, Shannon. The Ledbetter Fair Pay Act was the first bill signed by President Obama when he came into office, and it essentially overturned a recent Supreme Court decision. And under the Ledbetter Act, an unlawful employment practice occurs when, number one, there's a discriminatory decision made or a discriminatory practice adopted. Two, an individual becomes subject to a discriminatory decision or practice, or three, an individual is affected by application of that discriminatory decision or practice. So what does this mean in a practical sense by way of example? Two people were hired in 1975. One was a man and one was a woman. The man was hired at $2,000 more, and it's unknown if the pay differential was for a discriminatory reason or not. Both received the same percentage increases over the years, so the woman continues to be paid less than the man. In 2009, the woman claims that the decision to hire her at a lower rate was discriminatory and that the decision has negatively affected her pay ever since. So the alleged discriminatory act happened in 1975, but under the act, her claim is not time-barred and she can be entitled to 2 years' worth of damages based on the fact that she continued to be paid at a rate that was based on a discriminatory decision. So what's the practical effect of this example? There's only 2 years of the statute of limitations, so the employer is not looking back all the way to 1975. The employer will just have to pay damages for the previous 2 years. Practically, how does an employer defend its actions from 1975? How are these cases is going to be litigated? What if decision makers are no longer with the company, or quite possibly, depending on how old the claim is or how old the decision was, not even alive? So this issue is going to be and has proven to be difficult for employers to deal with. One that I want to note is that this act was retroactive to May 28, 2007, so we immediately saw cases jump out back to that date. It also applies to claims of discrimination under various statutes, all of which are listed on the slide. The Ledbetter Act was passed. We've seen an expansion in the kinds of causes of action brought on Act, and these aren't just pay claims. We've seen failure to promote, failure to transfer, failure to grant tenure, all kinds of decisions that would ultimately relate to someone's pay. The Allegheny County case that's listed on the screen is a decision from here in Pennsylvania, and it's an interesting one. There, the plaintiff claimed that the employer's failure to respond to her request for wage increases resulted in her being paid less than similarly situated males. After the Ledbetter Act was passed, the Third Circuit reversed itself and held that the employer's failure to respond to the wage increase request was a compensation decision that was a continuing violation under the Ledbetter Act. And we're seeing examples of this case played out across the country. Although the Ledbetter Act is far-reaching, it's not limitless, and the Supreme Court recently ruled in a decision, AT&T Corp, that shows some of those limits. What that case says, and the significance of that case, is that if a decision wasn't illegal when it was made, but would be illegal if it were made now, the Ledbetter Act isn't going to let plaintiffs go back and claim discrimination on that decision. The decision has to be illegal when it was made. And this Supreme Court case involved the Pregnancy Discrimination Act, which was enacted in 1978. Plaintiffs tried to go back to a decision made before the act was in effect, but rely on its protections, and the Supreme Court said that that was not going to be possible. The Genetic Information Non-Discrimination Act, or GINA, prohibits employers from discriminating against applicants and employees based on their genetic information. And you might be wondering how this act could really have an effect on you as an employer and who has access to this kind of information anyway. But you should know that the information that's protected by GINA can come out of something as benign as a family medical history form that an employee might fill out, or through health risk assessments, and all of a sudden the employer has access to now protected material and will want to be careful about that. Some significant impacts of the law that are up on your screen. There's a couple things I'd like to point out. The GINA Act could bring into question wellness programs that employers have, which may involve employees completing health risk assessments, as I just discussed, that could request certain genetic information. It also impacts employers who require medical exams as a condition of employment. So employers who have such programs will want to reevaluate them in light of GINA, and employers should also think about reviewing their group plans to determine how genetic information is used under those plans. As you're probably familiar, the ARA subsidy, American Recovery and Reinvestment Act subsidy, is a COBRA subsidy to make health care coverage more affordable for employees who have lost their job. So what it does is it allows employees to purchase additional coverage at 35% of the ordinary cost, and then employers subsidize the remaining 65%, but are eligible to recover that money through a federal credit. These provisions have now been extended. The eligibility period for qualifying terminations has now been extended to the end of this month, February 28th, and the subsidy period has also been lengthened. There was a further extension in an earlier version of the jobs bill, but it's not in the current version, so right now this is the only extension. And one thing that is important to note is that under the extension, employers are required to provide notice. So for employers listening out there who haven't provided that notice and should have, you should consult with your employment counsel about that.
At this point, we're going to talk about what's pending on the federal legislative front. One thing when we talk about legislation that I suggest you take note of is the names of these bills. they're often carefully crafted. And think about the impact that that has on legislators who are going to be forced to vote against these. I'll give you a good example. Who wants to vote against, be on record as voting against the Patriot Act in the wake of 9/11? So think about that when you look at these and the significance that it places. They're often very carefully crafted, particular legislation that's being crafted by special interest groups, unions, whoever it is. They do it very carefully. Said at the beginning, given the strong pro-employee messages espoused by President Obama and the congressional Democrats during the 2008 election into the start of the 2009 term, many observers expected to see sweeping overhauls of federal legislation and regulation in many areas. So far, that hasn't really happened, but there's significant legislation pending, and in addition, additional resources are being poured into enforcement of existing laws by federal agencies, which could also have a significant impact on employers, and we'll just touch briefly on that. So we see legislation coming that could expand employee protections in further areas. You see listed, we're going to talk briefly about these areas. The first that we're going to talk about is union organizing. Perhaps the bill that received the most press long before it was ever actually introduced in 2009 is the Employee Free Choice Act, or EFCA. I'm sure everybody has heard of it. Three main provisions. One is eliminating the employee right to require an NLRB election and instead allowing the NLRB to certify a union as the exclusive bargaining representative based on a showing of signed authorization cards by a majority of employees in the proposed unit. That is what has gotten the most press in terms of eliminating secret ballot elections and whether that's un-American. The second is that it creates binding interest arbitration for first contracts if the parties can't negotiate an agreement within a very quick time frame, and there are steps within that about going to mediation and all those things. And third is increased penalties that are provided for violations of the National Labor Relations Act, particularly during organizing periods or first contract, and there's significant increases in the penalties. It's widely believed at this point that as introduced, EFCA cannot pass, that it doesn't have enough support. So what you see both legislatively in the press and discussions about behind the scenes is there are a lot of alternatives being bandied about. On the next couple of slides, we're going to talk about some of the legislative alternatives that are actually pending. And in fact, several of those were introduced before EFCA actually was in anticipation of EFCA. But perhaps more significantly, there has been talk about compromises going on behind the scenes. For example, there has been discussion of getting rid of the card check and instead replacing it with a fast-track election process with limiting employers' rights to conduct what are called captive audience meetings, that is, requiring employees to attend meetings so the employer can talk about why they shouldn't vote to unionize, or giving unions equal access. On the issue of binding interest arbitration, there has been some discussion of limiting it to only certain contract terms. So, for example, just certain economic terms instead of having an interest arbitrator decide, for example, what your layoff provisions are going to be or what the management rights clause is going to say, but limiting it. And also there has been discussion about going to parameters or even doing something like a baseball-style arbitration, which is basically each party submits a last best offer and the arbitrator just can choose between them, cannot broker any sort of a compromise. It's one or the other. The idea being that that would force parties to be more reasonable because if they seem really extreme, it guarantees that the arbitrator will choose the other side. All of those things are in play. EFCA picks up legs again, as many people believe it will, once healthcare is out of the way. That would be very significant for employers. It will significantly expand the number of employees who unionize, and the binding interest arbitration provisions are perhaps the most troubling for employers because you are losing control over the terms of your first contract, and not only the contract from which other contracts built. So what are the alternatives that are out there legislatively? One is the Secret Ballot Protection Act. This was introduced as a countermeasure to EFCA. It would actually go the other direction and make it an unfair labor practice for an employer to recognize or bargain with an employee in the absence of an election. Right now, an employer can voluntarily recognize a union based on a majority showing of support. Many employers do not, but it would actually prohibit it. And the intent was to preempt the portion of EFCA that would make the secret ballot election optional. Also, bill pending National Labor Relations Modernization Act, another alternative to EFCA. It would not get rid of secret ballot elections. Instead, this would give equal access to employees by months prior to the election. So an employer would have to tell the union about campaign activities it intends to engage in. If there's a meeting with employees or it distributes litter or posts signs, then the union gets the same access. One of the major motivating forces, at least in the press, of the unions pushing for EFCA is to say the deck is stacked because employers threaten people, they keep employees hostage, they've got all this access to employees that we don't have, and that's why the deck is stacked against unions, and that's why the share of unions of unionized employees in the country has been steadily declining in the private sector. So these are intended, the National Labor Relations Modernization Act, and some of the other alternatives to EFCA that have been discussed, even if not introduced in legislation, are an attempt to deal with some of those conditions rather than the sweeping overhaul of the process that EFCA for. Other alternatives, the Labor Relations First Contract Negotiation Act. It would require mediation and binding arbitration of initial contracts if no agreement is reached within 60 days, so trying to just peel off that portion of EFCA. There's also moves to expand who has bargaining rights, so you see a bill pending that would give collective bargaining rights to graduate students who are teaching as part of their degree program. This is directly to overturn prior NLRB decisions on this issue, which found them to be students, not employees within the meaning of the Act. Things in the area of union organizing, labor relations that are pending, Freedom from Union Violence Act, which would increase penalties for violence related to labor disputes. Truth in Employment Act would allow employers to file SALTs. SALTs are people who take a job with an employer for the sole purpose of organizing the union in that location, so they don't actually intend to be and remain employed. The Worker Eligibility Fairness Act would allow strikers to be eligible for food stamps and other federal nutrition program benefits. In federal and in a lot of states, people who are on strike are disqualified from certain assistance benefits. The Employer-Employee Cooperation Act, I think, is actually one of the more startling things that's pending, just in how it rapidly and dramatically changes the relationship between state and federal governments in the area of labor law. Typically, the National Labor Relations Act has authority over private entities. Public entities are governed by state labor relations act or by state law, but this statute would allow the Federal Labor Relations Authority to decide if the collective bargaining rights of certain public safety employees, police officers, firefighters, corrections officers, are sufficiently protected by state law, and if not, actually take jurisdiction over labor relations for those employees, prohibit strikes and lockouts for those public safety employees, which many states do anyway. In some states, police officers and firefighters, other public safety employees, have the right to bargain. In other states, they do not. It's a question of state law. But here's the federal government suggesting that they would reach down and say, state, we don't think that you give these employees enough rights to bargain. We're going to take over and give it to them. That would be a dramatic shift in the federalism relationship between the state and federal governments, and there's been questions about whether or not that would actually even be permissible under the Constitution. If it's passed, it will certainly be challenged by state governments. Another interesting bill that's pending is, again, I focus here on the Rewarding Achievement and Incentivizing Successful Employees, the RAISE Act, which would allow employers to give individual performance bonuses to unionized employees without bargaining. Many would say that that's a way of undermining the union, but it's an interesting act nonetheless. And with that, I'm going to turn this back over to Katie, who's going to talk about what's happening in the area of employment discrimination.
I talked about the Ledbetter Act, and now I want to talk about some pending federal legislation that also goes to the issue of remedies for pay discrimination. The Paycheck Fairness Act provides additional remedies for people who claim discrimination under the FLSA. The Fair Pay Act doesn't cover compensatory and punitive damages, so this act would allow for that. The Fair Pay Act of 2009 expands the FLSA to cover pay discrimination on the basis of sex, race, or national origin. And you're probably thinking, well, those claims are already covered. But what this act would do is provide an additional avenue for employees beyond Title VII, which would obviously already cover those kinds of claims. Under this act, and compared with Title VII, there would be different remedies under the two statutes. There would be different agencies to enforce the statutes, and there may not be a requirement to exhaust administrative remedies like there is under Title VII. The Title VII Fairness Act aims at expanding individuals' rights to file claims of discrimination. So what the statute does is it provides that the trigger for the statutory period to file a charge, which is 180 days or 300 days, depending on the state, that trigger would only kick in when the employee has or should be expected to have enough information to support a suspicion of discrimination. And so what this legislation is trying to do is get at the situation where an employer might sit on evidence that a certain act was discriminatory until after the statute of limitations has run, and then ultimately escape the effect of its discriminatory act when the employee had no way of knowing that he or she was ever discriminated against. This act would also expand the filing periods under the Age Discrimination and Employment Act and the ADA. The Employment Non-Discrimination Act is yet another discrimination statute, this time an extension of Title VII. This act would prohibit discrimination on the basis of actual or perceived sexual orientation or gender identity. This issue has already been addressed in many states. 21 states in the District of Columbia have laws prohibiting discrimination based on sexual orientation, and 12 states have actually extended that to protect gender identity as well, and this legislation would extend that protection on a federal level. The Arbitration Fairness Act is related to the discrimination statutes that we've seen as well. What it's trying to do is limit an employer's right to require employees to arbitrate employment discrimination claims rather than pursue them through the court system. The House version of this act says that an employer can't require an employee to arbitrate discrimination claims, but it was silent on collective bargaining agreements. After it was in place, the Supreme Court issued the Penn Plaza case, which held that a collective bargaining agreement could require discrimination claims to be arbitrated. The Supreme Court took the position that the union has the right to waive that right on behalf of the employees as they are the employee representative. So in reaction to the Penn Plaza decision, the Senate version of this bill includes collective bargaining agreements. As a practical matter, the inclusion of the collective bargaining agreements to the Act isn't too significant because most collective bargaining agreements contain these provisions anyway. In addition, those of us who practice in labor arbitration and those employers out there who deal with labor arbitration might agree that it might not be the most appropriate venue for those kinds of claims to be litigated anyway. The issue of employee leave, we see a number of proposed statutes that relate to paid sick leave, and this is particularly in response to the swine flu pandemic that has been in the news for the last year or so. We see a growing concern between people needing and wanting to balance their family obligations and people not being able to take sick leave because they need the pay. And so we're seeing a lot of paid sick leave legislation being proposed, and there's some examples of that on your screen. We're also seeing many forms of expansions of the Family Medical Leave Act. The Family Leave Insurance Act is one of the most radical. It would provide for 12 weeks of paid benefits. These benefits aren't paid by the employer. What would happen is it would be set up more like the unemployment or workers' comp type benefits, and there would be a creation of the Family and Medical Leave Insurance Fund which would be funded by premiums paid by employers and employees. And for those of you who are familiar with the systems in place in California and New Jersey, this act, the Family Leave Insurance Act, would be similar to those systems. With these acts here, we're seeing an expansion of who and what is covered, what kind of leave are covered under the FMLA. So the Family Fairness Act eliminates the hours of service requirement that currently exists under the FMLA. And what this does is it pulls in part-time employees and also allows people who already taken leave to more quickly reset that leave eligibility than they're able to under the FMLA currently. The Domestic Violence Leave Act expands what is covered to address domestic violence, sexual assault, or stalking, and it also adds domestic partners. The Medical Leave Enhancement Act would expand the FMLA to pull in a smaller size of employer, and it would also permit leave to be taken for parental involvement. This kind of leave has become popular in the state arena. And this is yet another example of FMLA being amended to pull in, or trying to be amended to pull in more employees and cover more kinds of leave. First, Shannon covered the few significant changes to FMLA that were actually favorable to employers. She pointed out that employers can now directly contact an employee's doctor for clarification, and that employers are allowed to disqualify employees from perfect attendance bonuses. The Family and Medical Leave Restoration Act that you see here would essentially reverse those changes. The Balancing Act of 2009 is interesting. What it does is incorporate many of the changes to FMLA that we saw in the other bills that I just discussed and just puts them in one place. So you see how it is expanding who is eligible for FMLA. You see the 12 weeks of paid leave. You see the paid sick leave component that we talked about. The parental involvement leave is there, and also the leave for issues related to domestic violence. So it's everything that we just talked about all rolled into one statute. The Families Flexibility Act, again pointing out the title of these acts and how manipulative sometimes they can be. The concept behind this act is to make it easier for employees to request more flexible work schedules. And this is part of the family-friendly legislation that we're seeing. And although this act doesn't provide any additional substantive right to employees, what it does is creates a minefield of process for employers. So the employee has the right to make a request for a schedule change for any reason. The employer then can't just reject the request outright. It meet with the employee about that request, and in that meeting, the employee has the right to have a representative there, which could potentially be a lawyer. There's nothing that is in the law as it's written that would prevent it from being a lawyer. The employer then, if denying the request, has to provide a written denial, including an explanation for any claim of hardship. If cost was an issue, the employer might have to show why it was unable to afford such a request, and that could get difficult. The employee then can seek reconsideration of the decision, which would lead to another meeting and another written explanation, and it just goes on and on. So you can see how this could really create a procedural nightmare for employers. Here, the Paid Vacation Act, we see yet another way of resolving the tension between people's obligations at home with people not being able to take time off because they need the income. This would amend the FLSA to require certain employers to provide some form of paid annual leave. The Family Friendly Workplace Act, what it would do is allow employees to earn leave in lieu of being paid overtime. This provision exists already in the public sector under the FLSA, so this would be a similar application in the private sector, and some version of this has been bouncing around for years, and again it shows the tension between people wanting time off and wanting to get paid. This statute has been opposed by unions. It has been supported by some employer groups who see it as a potential way for employers to reduce overtime. It also has been supported by some employee groups who do see the advantages to the employee. It is at the employee's choice whether they want to take comp time or overtime, and it also could give employees more time off work if they need it or want it or can afford it. With the minimum wage statutes, we see the tension between protecting workers in a bad economy with protecting businesses in the same bad economy kind of environment. So the first two are examples of pro-employee statutes that under the minimum wage topic, and then a pro-employer one, which would amend the FLSA to postpone certain increases. These job protection statutes are also the function of a bad economy, with the Federal Oversight, Reform, and Enforcement of the WARN Act, or cleverly called FORWARN. It extends WARN to more employers, so employers with 75 employees instead of 100 would be covered, to more situations, so layoffs of 25 or more employees instead of 50 would be covered, and it requires employers to provide more notice, 90 days instead of the current 60. Women insurance legislation, here we see a few pending statutes that would help states or encourage states to provide for additional unemployment benefits through use of incentive payments or subsidies, and we've listed those examples there. I'm going to turn it back to Shannon to cover some federal agency activity.
As I said earlier, we although haven't necessarily seen huge changes in the legislative front on the federal level, what we've seen is increased agency activity and stepped up enforcement, which we anticipate is going to continue as there's been increased financial resources for enforcement being poured into the budgets of things like the EEOC and the Department of Labor. Federal agencies are also being reshaped by the appointment of officials who are more likely to push employee-friendly interpretations. Perhaps the most hotly discussed at the moment have been nominees to the National Labor Relations Board. The NLRB has been with only 2 members for a period of time, and the president's latest appointment has stalled. There's been some talk that there will be a recess appointment to the board. The NLRB is significantly affected by its membership. Typically what we see is that the NLRB has not hesitated to overturn decisions of previous boards when the presidential administration changes. So that could be very significant. There have been new appointees to the Administrative Review Board. The Administrative Review Board reviews things like whistleblower claims that are also expected to be significantly employee-friendly. Also positions like the Secretary of Labor, which has announced a very employee-friendly pro-union stance, and her background comes from that. In terms of increased enforcement, the Department of Labor under Secretary Solis has announced increased enforcement initiatives. The EEOC is widely expected to be more aggressive in pursuing litigation against employers and has been given additional resources to do that. The IRS has suggested that there's going to step up enforcement efforts to combat employee misclassifications as independent contractors. We'll talk a little bit more about that later, about the significance of that misclassification, and we would expect to see increased enforcement efforts by OSHA as well. Of actual regulations, we've seen interim final rules issued in February to implement the Mental Health Parity and Addiction Equity Act. Those could take effect as early as July of 2010. Proposed rules have been issued by the EEOC under the ADA Amendments Act that we talked about earlier, and the interim final rules have been issued under GINA. Moving on to legislative activity. Mentioned in the beginning, we are going to just really be giving some of the highlights of what's going on at the states. I'm going to be hitting sort of the big themes that we see, not talking about every state or every bill, and focusing where the states are pushing the envelope to impose additional obligations on employers than what you see at the federal level. You know, states passing legislation that basically brings it into line with what's going on at the federal level. For the most part, I don't consider that as significant as where the states are going beyond what the federal government requires, because that's where employers are going to be in a situation where they're going to be forced to act. Another I want to talk about is captive audience meetings. When we talked about EFCA and the alternatives to EFCA, I mentioned that this is a big area in the public debate about EFCA, about union organizing. Unions have pushed very hard on this idea that part of the reason that unions are not successful in organizing in the way that they might have been, let's say, 3 years ago, is because employers has captive audience meetings where they can threaten, they can coerce employees to not vote for the union, and this typically happens very close in time to an election. A number of states have passed legislation that prohibit these captive audience meetings. We've seen some states pass them already in prior years. Oregon was the latest, the state that became effective in January 1st, 2010. What's interesting about these bills on their face, however, is that many of them, and there is a sort of a model legislation that's been introduced by labor unions that you see pending in a bunch of states, it prohibits employers from taking actions against an employee who refuses to attend a meeting or participate in communications concerning the employer's opinion about what is typically called religious or political matters. So if you're a legislator and that comes before you, well, that sounds reasonable, because why should an employee have to sit through hearing about an employer's views about religious or political matters? But then it's only when you go back and you look at the definition in the statute that you find out that political matters includes organizing. It includes whether or not to join a union. So really what these are doing is prohibiting captive audience meetings and trying to prevent employers from talking to their employees about whether they should unionize in the midst of an election, but they don't on their face, unless you look carefully, that's not immediately apparent. A number of states have bills pending that would follow the line of the Oregon statute, and we've seen that in past years, and we expect we'll continue to see it. A handful of states have actually passed them so far. Another area where we see states trying to sort of model what's happening with EFA is there are states have enacted or proposed legislation similar to EFCA that would allow card check recognition. We see Massachusetts, which actually passed that law. Hawaii enacted it over the governor's veto. Utah, several other states on the other side have proposed constitutional amendments to preserve secret ballot elections, and Utah is actually scheduled to be voted on in the November general election. With that, I'm going to turn it back over to Katie, who's going to talk about the issue of independent contractors.
So, of misclassification of employees is gaining more and more attention these days. President Obama recently proposed his budget at the beginning of this month, and it gives $25 million to the Department of Labor to target this issue with additional enforcement personnel and competitive grants to enhance the state's ability to address the problem. The IRS is also paying attention to this issue. It has begun a 3-year study on this issue this month, and also has begun auditing 6,000 companies to ensure compliance and to make sure that employees are being classified correctly. This is a big issue these days for the federal government because there's a lot of potentially lost tax revenue involved, and for the same reason, it's also becoming a big issue for the states. So employers who use independent contractors need to be aware of the consequences of misclassification. There's the tax liability concerns that I just talked about, where employers may have been required to be paying taxes on certain individuals that they were not. Their failure to pay benefits, so there was the workers' comp, the unemployment, the health benefits. There could be wage and hour implications if the person who was classified as an independent contractor should have been actually an employee and should have been earning overtime. And the states are focusing particularly on the construction industry for all of the reasons I just mentioned, but also because of safety concerns, because of the injuries that can occur in those industries that are ultimately not covered. Here we see examples of states that have started cracking down on this issue. These states have enacted statutes that provide, some of which provide civil and criminal penalties or the debarment from public contracts for misclassification. Some states are more generally prohibiting misclassification or clarifying the criteria, and you can see examples there. And even if states aren't pursuing this through legislation, states will certainly start enforcing the issue more. One example is New York, who has implemented a task force on this issue. Another thing on the issue of classification and misclassification of employees that you should know is that there are many federal tests for who is an independent contractor. IRS has its own test. There's various statutes that have their own tests that define employee and independent contractor differently. And of course, states have their own definitions as well. And some of these tests can be contradictory, or an individual could be covered as an employee under one and not under another. And so it has been tests have made it difficult for employers to stay compliant. So now that this issue is a hot topic and on the forefront, employers should be aware of how they're classifying their employees.
We're going to talk about the issue of paid leave. And we saw on the federal level, as Katie discussed, that there is a lot of pending legislation dealing with expanding paid leave rights. And we see that in the states as well. There's a lot of legislation. There have been a number of states that passed legislation in 2007 and 2008 requiring employers to provide paid leave in certain circumstances. We've seen a slight slowing of that trend in 2009 without as much significant new legislation in this area being passed. And I think that may be in part a reflection on what happened with the economy in 2009. And there are a number of states that have bills pending that would expand paid leave rights in a variety of circumstances. Again, what we see here is this tension. It's, we've got the FMLA. The FMLA doesn't cover every employee. It doesn't cover every circumstance. And there is, I think, a concern among legislatures that even in circumstances that are protected by the FMLA, that any employees, especially low-wage employees, can't afford to take the leave because they can't afford to miss a paycheck. So we see that in both states trying to add paid leave and also trying to get at areas that are not protected by the FMLA. Ending paid leave legislation, as I said, covers a variety of reasons. If you look at the list that's on the next few slides, you'll see it mirrors some of what you see at the federal level. You see things like mandatory sick leave pending in Iowa and Maine, Missouri specific to birth of a child or adoption. We see states like Iowa and Wisconsin looking specifically at, veterans getting Veterans Day off. More generally, I think what you see is things like New Jersey with paid sick leave, or New York paid sick leave that sort of mirror what we're seeing on the federal level. Another trend that you're going to see generally both here and in some other bills that we're going to talk about on the state level, and you saw it on the federal level as well, is an increased attention to victims of domestic violence, and I think a recognition that they don't necessarily fit into the current sort of protective scheme, not protected class, not eligible generally for leave benefits even under the FMLA necessarily. So if somebody has injuries as a result of domestic violence, it could be that they qualify for FMLA protection, but it might not. But then all of the other things that relate to it, housing issues if somebody has to move as a result of domestic violence, legal proceedings, and all the time that it takes and the distraction, counseling that may be required, that may not rise to the level of being a serious health condition under FMLA. There's concern for that. So we're seeing that Philadelphia, for example, in 2009 passed legislation that requires leave for victims of domestic violence that is intended to run concurrent with FMLA leave. But of course, not all of those situations are going to qualify for FMLA leave. And Philadelphia is not the only place that's looking at that issue. Also see increased protections against discrimination at the state level that in some cases mirror what's going on at the federal level, and in other cases even go beyond it. You saw that at the federal level there's legislation pending that would expand Title VII to protect for discrimination based on gender identity or sexual orientation. That has taken effect in a number of states, so California, Delaware, Iowa. The District of Columbia also has passed protection against that, many other cities as well. Interestingly, the newly elected Virginia governor signed an executive order just a few weeks ago removing sexual orientation from an executive order that had been signed by his predecessor, generally prohibiting discrimination against state employees. So this only applied to state employees. It was protected, and now it has been removed. Protections for sexual orientation or gender identity are also pending in a number of states, and typically these are amendments to state anti-discrimination statutes, which nearly every state has, often that mirror the federal bill, sometimes also go beyond it. area of significant interest on the state front is dealing with protections of criminal histories or background checks. Many states have statutes that limit how criminal histories can be used. A number of states looking at the question of background checks and what information out of an employee's background generally can be considered in employment decisions. I think we see in a tight job market some concerns about hiring qualifications and barriers to employment. The EEOC has issued guidance in the past suggesting that use of arrest records is racially discriminatory because of the disparate impact on minorities, and that's specific to arrests. Now, in Pennsylvania, the PRC, the Pennsylvania Human Relations Commission, has proposed guidance that goes even further and suggests that use of a criminal conviction to disqualify a minority applicant is presumptively racially discriminatory because minorities have disproportionately have criminal records. Pennsylvania has a statute that provides that an employer can consider a criminal history as a disqualifying factor in employment under certain circumstances. Now the PRC is saying in guidance that they have proposed that you do so and you disqualify somebody who's a racial minority, that's going to be evidence of race discrimination. Other states that are looking at the use of background checks, you can see Hawaii actually enacted a statute prohibiting credit histories in hiring and termination decisions unless it directly relates to a bona fide occupational qualification. So for example, if you were hiring somebody for a finance position and they had been convicted of or had a history, that related to sort of an inability to manage finances, that might be disqualifying. Other states are looking at doing that in a number of ways as well, and you can see those there. And there are a number of states that are looking at different things, both ratings or criminal records. Of discrimination that have been looked at and are being looked at by states. What you see is there are a number of bills protecting victims of domestic violence from discrimination. As I said, similar statutes were passed in Illinois and New York. In Oregon, Indiana has a maximum age for age discrimination, and they've increased that from 70 to 75. Under the federal level, there is no maximum in that way. In New Jersey, requiring affirmative action related to some state contracts. You see states looking at other expansions of federal protections that are significant. I note on Michigan, prohibiting discrimination because the employer is or believed to be a legal owner of a firearm. There are some other states that have passed legislation in past years that specifically, for example, allow employees to bring guns to work. There have been employees who were fired because they had a gun in their car, things like that. So states looking at issue. I also know one of the more interesting ones, Michigan, the bill in terms of expanding their anti-discrimination statute would include height and weight as protected classes. New York will, and this pending legislation, follow other states that protect volunteer EMS providers from employment decisions based on sort of missing time as a result of responding to calls. Another area I'm going to touch on briefly as our final topic is rest and meal breaks. You see a couple of main sort of trends here. One is looking at the issue of nursing mothers, and those sort of take two tacks. One is on the employment discrimination side, you see saying you can't discriminate against a woman for taking time off for expressing breast milk. You can't prohibit somebody from doing it. Other states are actually looking at requiring employers to provide unpaid break periods. Some states are looking at requiring employers to take reasonable efforts to make space available for women to do that. I think that's a reaction to more women in the workplace saying, wait, I shouldn't have to hide in a bathroom, or I shouldn't be fired because I need to go do this. And I think you see that picking up some popularity in states, and this is a trend that began a few years ago and is continuing. You also see states looking at a concern that employers are not adequately getting meal and rest breaks. States already have provisions that require meal breaks after a certain period of time or specific rest breaks. Other states are looking at it as well. If you have questions about your state or you want more information about how to stay on top of this, we do have a service that we provide for a flat fee subscription basis. It's a monthly subscription that tracks legislation throughout the country, both on the state and federal level in the employment arena. There is a link to it on our website, or you can certainly contact me for more information. And you have here contact information for both Katie and I if you have any questions, and we'll be responding to any questions that came in through WebEx as well. Thank you very much for your time, and we hope we'll see you on the next one. Bye.